I'll take up the matter EQT Production Company's motion for summary judgment. If you'd like to address that.
Yes, Your Honor. Briefly, the issue for motion for summary judgment is very succinct, Your Honor, and I'll get right to the point. The first issue is doctrine of unclean hands. This court is aware it's a matter of equity. In balancing the equities in this case, the court is considered unclean hands. Who has clean hands and unclean hands in the process? If someone has unclean hands in an equity action, they shouldn't be entitled to relief. You can't come to the court saying, well, I did all these things over here wrong, but you should give me relief. In this case, Your Honor, EQT did everything it was supposed to do, that it was told to do by county clerk, floodplain manager at the time, and the state coordinator in getting the issuance of the permit. We didn't know, Your Honor, that the floodplain was rescinded until we saw it in the paper the next day, April 18th. And let's not kid ourselves when we talk about how did they know to show up at that meeting, Your Honor. You can watch the video. I may have a copy of it here, Your Honor. It doesn't matter. Clearly, everybody in that room knew what was going to happen that night because Shirley Williams said, these were her words, we're going to put a stop to EQT's development. That was all before anyone else started speaking. So there's no question. There's unclean hands as far as lack of notice, regardless of whether the Open Government Proceedings Act is lawful or not, or whether we can bring a claim for it. They have unclean hands to rescind it the way they did. And had they brought a stop work notice and was providing information, we worked through that process, it would be different. But what we have, Dodge County, unclean hands. More importantly, the Huffs have unclean hands. Because this case, Your Honor, is not just about the rescission floodplain permit. It goes back further than that. The reason nothing was done between November and today, quite frankly, as far as the floodplain goes, is because we had a floodplain permit, which we had to have, had consideration of, and was part of the application process for the gas wells from the DEP. The DEP didn't issue our first gas drilling well until February of 2010. Shortly thereafter, in February 2012, 2011. No, 2012, this year. 2012, Your Honor. The representatives of EQT met with, maybe actually Mr. Richardson, he wasn't counsel at the time, or Stacy wasn't acting as counsel at the time for Mrs. Huff. They were at the site, they knew we were going to start drilling. What does Mrs. Huff have her son-in-law, David Richardson, do? Drill a water well on a well pad. Your Honor, that issue was litigated before Judge Bailey. You know what the answer is. He found it's unclean hands. He is not going to condone such conduct. They were ordered to flood, to fill the water well. They had unclean hands, no question about it. We're talking summary judgment on the unclean hands issue.
Well, the federal order did specifically say they had unclean hands. They're telling them they couldn't do that.
The ordinance, the order did not specifically say they have unclean hands.
I don't think so, because that brings me to a question I want to ask. Is it unclean hands more of a substantive doctrine that doesn't necessarily look at people's conduct in advancing or protecting their rights, or their motives or their intentions, as opposed to something that they may do a little bit more substantively to create various inequities in proceedings as the parties' interests are viewed vis-a-vis each other?
I think it can be both, Your Honor. And here's what the substantive, obviously, yes. I mean, you can't go out there and do something and say, Judge, hey, you did this. But it's also procedurally, and with the issues in a case like this. This is a perfect example of as to why the unclean hands doctrine exists. The unclean hands doctrine doesn't allow people to go take the law into their own hands, so to speak. And this overall scheme by Joy Huff is to block these gas wells. We'll do whatever it takes. Your Honor, she's called the DEP. There's plenty of emails. She's called Army Corps of Engineers. We comply with every request that anybody's asked to supply information. Things are just clearly not issued. She's trying to block them. If we get our permit today, we're expecting some other activity. We know this may not be today because we have that. And that's unclean hands. You can't drill a water well in our permitted wellhead site. They knew where it was. We met on the site with them. And Judge Bailey said this: it was a gambit that he's not going to condone. Did he use the word unclean? No. But on the motion for summary judgment, there's no question of fact that that was unclean hands and improper conduct. But we got the injunction on that. Now, on those two issues of unclean hands, I don't think there's any question. The summary judgment is appropriate for those two. Now, regarding irreparable harm, there's no question of a proper interest in exploring for and attempting to and extracting this gas. We have a lease right to do so. There's no question, Your Honor, that we will be suffering irreparable harm if we can't drill these gas wells. The question was asked to Mr. Bowman in deposition a couple weeks ago. Did you look at any other well sites? First, there's no duty to, Your Honor. Yeah, we did. There's 6 different ones. We have maps we brought today that show locations of them. We have not been able to locate any other site on her surface, Mrs. Huff's surface, or off that's going to allow EQT to get the same reserves. In some locations, you just can't. It's just not geologically possible to do so. There are places in the meadow where we can't put the well pad. If we can't get this, we lose a property right. And the irreparable harm is a property right. We have a right to do it. I don't think anyone's in here contesting we don't have a right to drill for gas. That's not an issue in this case. In some cases it is. This one is not. So, as far as I'm concerned, Your Honor, it's straightforward. Our motion for summary judgment is very simple. Unclean hands for the county commission in the initial decision, not following the ordinance, recognizing some appeal that they didn't have. We go on down the line of that when it starts at 17. The Huffs with unclean hands, we're doing the water well, and irreparable harm, there's no question. We're just trying to narrow issues, Your Honor. As you know, the 4-part test and the preliminary injunction likely to succeed on the merit. I mean, preliminary and permanent injunctions is consolidated, but proceeding on the merits, balance equity, and then irreparable harm and public policy. Public policy, there's no question. It's public policy. We have irreparable harm, and when we balance the equities, they should be entitled to equitable relief because of the issue of unclean hands. Thank you.
All right, thank you, Mr. Payton. All right, who'd like to respond first? Go ahead, Mr.
Thank you, Your Honor. Mr. Leeson, I believe is misapplying the concept of it only involves the transaction issue, by his own words, the permit. If you look at his other motions in limine, the issue is very narrow, whether EQT has the right to the permit. When he gets to the motion for summary judgment, the issue becomes whether EQT has the right to drill and develop. He expands it so he can bring the Huffs maybe into the alternate issue of the case, not the one they've been arguing the entire time. The Huffs had nothing to do with the permit. That's what we're here for. That's what I'm is the permit. What's going on in Wheeling is going on in Wheeling. And that was a preliminary injunction ruling, and everybody has stopped because of this. There were technicalities in that case. I thought they got the preliminary injunction vacated, but it's not a waste of time. They still haven't properly served them. Further, there is West Virginia law that says that you can drill a water well to stop gas wells. And I have it right here. Diversified Resources v. Bradley R. Phillips. And the West Virginia Supreme Court denied cert. And say the Huffs acted in unclean hands when they were relying on what they thought was the law, a legitimate law. Again, water well has nothing to do with their permit. The water well didn't keep them from getting a permit. And if you're going to invoke equitable remedies, and you're going to get an injunction, you got to have clean hands yourself. And first of all, I maintain my objection about this motion for summary judgment because it wasn't properly noticed. There was not enough time, different rules for different people. We're talking about notice. And we only got 8 days instead of the normal 10, and that was with the weekends not being excluded. That was a true 8 days. while doing travel. But I have an opposition that I wrote, this morning, just in case we actually heard this. And it doesn't have everything that I'd like on it, but it's got a few things. Page 18 of the ordinance, if you're going to have a development that is 2 acres or larger, you have to delineate a floodway if you're doing it in a flood, proximity flood zone, like the huts, where there isn't a floodway. You have to, as part of the permit application. It's ordinance, section 5.4, site plan, criteria, D, page 18. EQT failed to delineate a floodway. And by the modeling by our expert, our 40-year engineering expert, Stuart Gilbert, half of the football-sized field, well pad is going to be in a floodway. And there are a whole different rules about putting a field in a floodway in the ordinance.
Your Honor, briefly, and again, I don't know if I'm interested in arguing, but in order to move this along today, I would appreciate Mr. Richardson responding to the motion issue. A motion for summary judgment is their unclean hands, not our unclean hands, the way we have it. And I know I argued that, and it's not a floodway. We're getting way off basis. The issue in this is whether the Huffs have unclean hands during the water. Well, that case is not said, was not the same basis for the decision that Judge Bailey ruled in Wheeling. I was there, as you can just argue that they specifically did to stop this. And it is all one transaction. It's over. If the floodplain is irrelevant, the drilling water wells are irrelevant, the gas wells, if we don't have a floodplain. It's all the transactions. It's one big scheme transaction. What we're here today on the entire transaction is whether we get the floodplain permit to go ahead and move forward. In fact, the DEP issued the rest of the gas wells after they knew our floodplain permit was rescinded. DEP wants these wells in the ground. And so and with respect to the late filing of this motion, it is. DEP is correct. I did not follow Rule 56 with respect to the 10 days on this motion. I respect his position on that. If you don't want to, if we can talk about late filings all day long, we got one at 5 o'clock last night, the supplemental expert report after it was after 5 o'clock, but I think I got Mr. Henderson was gone. And I still haven't had a chance to look at it. But, and so if you want to refer that issue to the direct verdict issue, or I'm sure, of course, we'll hear it anyways, I'm happy to do so, Your Honor, but I respect his objection on the notice of that. So I'll write that clear.
You know, it goes, it has to, that's not important. And going back to what they were saying, they've been applying all along their own. I mean, I know he doesn't want to bring up the unclean hands statement, but if you're going to get the equitable remedy, your hands have to be clean, and that's the only reason I'm bringing it up. I'm not bringing it up just to make it look bad. That is the nature of the beast when it comes to equity, and especially injunctions. You don't get injunctions if you have the dirty hands. And there's violations of the ordinance, the failure to delineate, their expert floodplain study. The ordinance says it has to be undertaken by a professional engineer, and undertaken is where you first would assume. They had 2 cabs.
Mr. Richardson, just a minute.
Sure.
I understand what you're saying, your arguments with regard to the impropriety of EQT's action in complying with floodplain ordinance. But I think specifically on the issue of the motion for summary judgment, if you could address the equities of the unclean hands as they've alleged it against your client for purposes of supporting their summary judgment.
Okay. Like I said, our client was acting under case law, under West Virginia case law, that says you can grow a water well, and the judge said, I don't care. I'm not even going to consider, why they're doing it. It doesn't matter. So, for them to say you stuck in the middle of the night on your own property with no authority, it's absurd. I mean, they're making the Huffs out to be these mastermind geniuses, but they were just following what they thought the law was. And whether a federal give weight to a circuit court of West Virginia, that's another matter. But as far as my clients were concerned, they had authority under the law to act. And, yes, yeah, sorry, if I'm not going to argue the unclean hands of EQT, I will stop with that.
Mr. Bennett.
Your Honor, for the Dutchess County Commission as it relates to unclean hands as asserted by EQT, in particular to the action of the Dutchess County Commission on April 17th, was a mistake made of entertaining a vote on the evidence that was presented by the House of Officers. Yeah, that's technically a mistake. But you have to remember, the evidence is going to show that they consulted with Mr. Sneed at the state level, who is the technical advisor, and he also had the opinion that the permit stop order should be granted and advised the floodplain manager of that fact. So my argument is that we have in Dodgers County good public servants trying to do the job that they're asked to do. None of them are attorneys. To my knowledge, on April 17th, the prosecuting attorney of Dodgers County was not at the meeting, and they relied on their own instincts. They did one step further, which they called Mr. Sneed, and Mr. Sneed said, yes, issue the stop order, or stop the permit. Let's look at all this evidence that evidently was presented to you, because I hadn't seen it. That was essentially what went on there, and that's where it went to a rescission letter. And then thereafter, opportunities were had where EQT could come forward with more evidence. They had filed their litigation. They put their lot and their bet on the fact that this court would change the action of the Floodplain Appeals Board and decided not to present any evidence at a public hearing where they had every right to do so. And they understood that hearing was going to be held, and they were even present. So my argument is that our good public servants in Dodgers County did their job and gave EQT proper opportunity to present their evidence.
Thank you, Mr. Bennett.
Your Honor,
Just a second, before you jump back in. Mr. Stevens, any reply?
I have nothing to add, Your Honor.
May I proceed, please?
thank you, Your Honor. Yeah, just so you're clear, we did not move for summary judgment on any unclean hands or Mr. Foster on a motion. The water well was an issue until we got our gas well permits from DEP, and that was the way, that's the first thing to stop us. That's the way to stop us from that time. Because state law says you can't drill a gas well within 200 feet of water well at the time. So we couldn't move forward. They stopped us. So that bought them time to go to the county commission to get this overturned. And again, let's not fool ourselves. Mr. Tennant just made some interesting statements, which is clear, I think, between the parties. I'm not picking on Mr. Tennant. But Mr. Sneed did contact the county commission. The county commission knew it was going to take place that night. Joy Huff knew it was going to take place that night. Mr. Foster knew it was going to take place that night. Why wasn't it on the agenda? Was there a special emergency agenda? If it's such an emergency that needed to be stopped then by act of the county commission, do a special emergency agenda. Put it on there. If we don't show up, that's our fault. And what's interesting is on the stop work notice argument as opposed to the rescission argument, I have no problems with Mr. Sneed getting information from a citizen of the state saying none of this stuff happened. You need to do something about it. Him contacting the county commission and saying you need to do what you need to do to stop this development because the information I'm getting is a violation of the ordinance. I have no problem with him making that call. I have no problem with the county commission relying upon that because he's obviously, as I said before, probably the most educated person in the state on these issues. They relied upon it. They could have issued a stop work order to work through these issues. They didn't. They rescinded it. There's a big difference there. They want to rely upon Mr. Sneed over and over and over and over to rescind the permit. Well, Your Honor, when Mr. Sneed told him, well, wait a minute, stop. EQT provided everything to me. EQT's in compliance. I checked with our FEMA representative, and they're okay. You should give them the permit. Now they're running for Mr. Sneed. Now it's bad to rely upon it. So they either had unclean hands in relying upon him to stop it improperly in April 17th, and this farce that we didn't present any evidence May 22nd, we objected because it wasn't proper. But by that time, we knew that Mr. Wellings had been appointed as an interim floodplain manager. And Mr. Sneed was the ongoing person to deal with Dodgers County because, quite frankly, the county commissioners didn't know what was going on. I emailed him stuff. Sure, they'll come into evidence. He had our floodplain study. He had our site plans. And the letters that Mr. Richardson's asking about, the engineering stamp letter, there was one thing that Mr. Sneed asked us to supply, and we did, Your Honor. The first one wasn't stamped. You know what he said? It's got to be stamped. Our engineer stamps it. And then Mr. Sneed says, good to go. He calls Shirley Williams before May 22nd, has a conversation with her, and he sends her an email. And Mrs. Williams, with all due respect, doesn't remember getting an email. She doesn't deny the conversation. It has to be unclean hands, Your Honor. But at that point in time, even if you want to give him the benefit of every argument, because it's our motion for summary judgment, and it's construed the facts and like most favorable to them, they never had, there's no question they didn't have authority on April 17th. And then on May 22nd, they had a basis to deny it. Pictures of the flood, Your Honor, say floodplain, it is going to flood. It has to, we're not disputing that. So we could bring pictures here all day long to talk about flooding. In fact, there's a motion limiting on it, because it's not relevant to whether we're entitled to a floodplain permit. So I don't think there's any question. Both the Dodgers County Commission and the Hubs had unclean hands. Thank you.
You're briefly extending here. Maybe my client will be gone this grant. Can I just start going there?
Go ahead, Commissioner.
Thank you. The Hubs had no problem with the drilling on the property. There's 20-something EQT wells. They're genuinely worried about that floodplain. There's an existing well that EQT drilled on the other side. They did a really bad job. It's all rock. It's an acre to create wetlands. That's why they're talking they can't drill in some parts of the meadow. There's wetlands now. EQT's already affected the meadow. It's already caused flooding. They admit right now it's going to flood, and now they want to put 30,000 cubic yards of fill into it. They wouldn't give us the floodplain. They wouldn't give my client the floodplain. We asked repeatedly, just for confirmation, you're not going to flood. You're not going to flood the neighbors, you're not going to flood us. They refused, they refused, they refused. I mean, at what point you have nothing left? Nobody's there. It's not like we were trying to get an unfair advantage. We're trying to protect, they were trying to protect the land, they're trying to protect the neighbors, and no one's there to help them. And again, this has nothing to do with whether Dodgers County revoked a permit inappropriately or whether EQT deserves a permit. I mean, we're litigating a case that should be in reeling. It is ongoing. It's unrelated to what this complaint says. He's bringing in new unclean hands from outside his motion for summary judgment. It's flooded before, it's got to right of course. You put in that dirt, it's going to go up close to 3 feet high. You put in that dirt, it's 3 feet high, and somebody gets trapped in the wrong spot. What happens? A legitimate concern. It's not like we don't want them drilling just because we don't like drilling, or we like they like their pretty methods. It's not how they drilling where they want. We love the drilling. It's great. Just not somewhere that's going to cause harm to the community. So that's an unclean hand. I don't know.
All right, Commissioner. Anybody have anything further?
Just briefly again, I'm the one telling us to move along and keep talking.
Yeah, that's always a bad question.
Next time, let's move forward. So, briefly, the reason I talked about prior flooding, and the May flooding in their honor, is the event that the last flood, I think, was a hurricane was off the coast in the Atlantic Ocean. I'm sure, with all due respect, we're not taking flooding lightly. That's why we paid an engineer to do this floodplain study, to make sure that we're not increasing the risks of flooding. You can, I mean, if Mr. Richardson's right, and no one can ever do anything in any floodplain, well, let's just move everybody off the Ohio River and move them so many feet. It doesn't work that way, Your Honor. It's a balance. And we're not saying that it's never going to flood. What we're saying is what we're doing is not having an unacceptable increased risk of flooding. We're complying with the ordinance. We're developing, Your Honor. And to me, to say it's going to flood again, and we want to promise it's never going to flood again. Your Honor, a storm can come right now and flood. It flooded before our gas well was there. It's my understanding that there's been floods in this county all over the place, but things related to man-made development not. So that's not the issue. And just one more thing on Mr. Tennant, as far as unclean hands goes, this May 22nd meeting that they had, it was 4 o'clock in the afternoon. Our floodplain permit was set to expire in 6 months from November 22nd. And it was issued for 6 months to get started. We couldn't get started. And so it's convenient, I understand their schedules and everything, but there wouldn't have been any time for us to do anything once that decision was made or what would happen on May 22nd. So they put it all the way down to the end of the day. And the court will recall, we filed our motion, our original petition in this case, to try to stop that meeting. Because the reason we filed it, Your Honor, because we knew where we would be and where are we. And I respect the court's position to find out what happened and to see if you're really going to have these issues at that time. If we've got our floodplain permit there, you don't have to hear me keep going on and on about it. So.
All right. Anybody have anything further?
Yes, Your Honor.
All right, briefly, Mr. Davis.
If they want to go with 12 well pad, they only want to drill 6, 7, maybe 8 wells. They can make it smaller. They've admitted that in testimony. They don't have a floodplain study prepared by an engineer. They have a floodplain study prepared by computer, aided drawers. People who use computers to draw. And when you're talking about people's lives, people's safety, you think you have a real floodplain study. One of our experts said it took them 2 minutes to realize their floodplain study was wrong. So fundamentally flawed. So I just, there's more to it than just the money.
Well, since we've got a couple of dispositive motions pending here, we've been at it for a little while. I'm going to take a brief recess while the court considers the matter. And we will probably be in recess for 10 minutes or so.